On part 1 of a review of Russell Laffitte's federal appeal, we focused on the background of the case and information about how Russell was actually the first one who began taking loans from clients placed in his care before he ever extended a single one to Alex. We also saw how he had intimate knowledge of Alex's financial situation, yet continued to give him fraudulent loans, and though he knew Alex's firm's pay schedule, continued to cash checks throughout all times of the year, making him more than a duped, unwitting accomplice. Today, we move on to more of the accusations put forth by his team in their effort to convince the court that he's innocent and deserves an acquittal or at least a new trial. Are any of those points valid? Let's get started. This is Legal Updates with Cassidy. Let's blame it on jury problems. Welcome. Now we get into his complaints that this appeal is based on. And this is that 2 of the jurors were replaced during deliberations due to medical issues. Russell's defense team has made a big deal about these jurors being removed, saying that it was done without their consent, and therefore Russell deserves an appeal. So let's get into those details. The deliberations began around 10:22 a.m. on November 22nd. That evening, at 7:45 p.m., the court lets the parties know that it's received 2 notes from the jury. Both of these were from the same juror, the first one saying that they need antibiotics. This was said at 7:21, and they said it could be delayed 1 to 2 hours. The second note said that same juror was feeling pressured to change their vote. Now, we've been through this when we talked about Alex's appeal and his request for a new trial. For the day, they cite State v. Franklin as a case involving pressure by the jury, because that's what Juror 630 is claiming, pressure by other jurors. Here's the thing. A jury is made up of people. Imperfect people. People are problematic. But some juries have those people who want everything their way and expect everyone to listen to them. Or you have the contrary ones that want to pick the opposing side just to argue. Or the ones that cannot for the life of them make a decision. And on the opposite side, those with no patience who get openly angry and impatient towards them. People-y. It's problematic, but it goes with the territory of picking juries from the general public. No amount of voir dire can effectively rule out all types of personalities that can wreck a jury. But here's the thing, we have to make do with that system because that's the system the U.S. government has appointed here. The court system is already overloaded, understaffed in many cases, and under-budgeted in most, if not all cases. So it's impossible to allow mistrials or do-overs for every little bump in the road. It means the court is not going to treat juries like it's daycare and listen to who whines the loudest. They're going to review the cases and weed out situations that, although unpleasant, are not actual obstacles to due process. True denial of due process would be some kind of bias or prejudice, racially, sexually, etc. Other things just have to be written off as people doing people-y things. Even when the complaints seem very shocking, if they did not deny due process, they're simply what? People-y. Pressure from juror to juror is a normal part of deliberations and is not an excuse or a good reason for appeal or a new trial. The court's response to the juror that needed to leave to get antibiotics was that this is not practical to send this juror home to get her medicine and then return to continue deliberations. Once deliberations begin, they're not really supposed to be interrupted unnecessarily. I mean, some jurors are actually sequestered during this time, but Judge Gergel requests any input from the parties, as he says, welcoming any thoughts anyone may have. Defense asked if jury could come back in the morning. The judge says there's no issue with the jury deliberating, there's nothing to indicate that the jury is stuck, no indication that there needs to be an Allen charge, and that they're trying to be fair, but it just strikes him that under this sort of situation, the better course is this is why we have alternates. But, Judge Gergel goes on, I want to hear from you about this. So the government side suggests that the jury be permitted to continue deliberating that night, especially since there's no indication that they're having issues deliberating. The judge expresses concern about having the jury return the following day because it's the day before Thanksgiving, and he says it's not in anybody's interest. And he said, I'm going to be honest. I'm kind of trying to protect the defendants here in this situation, and I don't think it's in your interest to try to force people to come back tomorrow. I don't like the effect that has on pushing people to a verdict. So here he's saying people are not going to want to come back the next day because it's the day before Thanksgiving. So if we tell them to go home and come back, they're going to hurry up and try to get a verdict out so they don't have to come back tomorrow. So he didn't even want to tell them that they had to come back tomorrow. And he said this is for Russell's benefit. He doesn't want the effect to push them to a verdict. Then there's a third note. So there's a group of jurors that are expressing concern about one of the jurors who has been on a jury before, and that this juror's experience is influencing that juror's ability to discuss the trial in a group setting. The juror's making comments about having been bullied as a juror before. It's alleged this juror won't consider any of the evidence, was hostile to hearing any debate from certain other jurors, and disagreed with the jury charge. Now this is serious because the jury has to accept and abide by the jury charge. When you start disagreeing with it, going against it, you're no longer qualified to be a juror. So the other jurors ask that the judge consider speaking to this issue so that they can proceed. But while this is being discussed, a fourth note comes. One of the jurors is asking to please be replaced by an alternate. They say they're experiencing anxiety and are unable to clearly make a decision. The judge says that this note is different from the person who'd written the first two notes. So the judge again welcomes suggestions from both sides. The government asked the court to relieve both the juror who was not following the law and the juror who needed to take her medication. This makes perfect sense because the one who's not agreeing to abide by the jury charge has to go. They're not in compliance. They no longer qualify. The person who needs medication, they can't have someone's health being risked here. This is exactly what alternates are for. After the government had their say, judge turns to defense. Says, Mr. Daniel, your suggestions, I value your experience. And he asks for the third note to be reread. The judge then tells the parties that he wants to speak to the juror who is refusing to deliberate, and he wants to do this with a court reporter present, but outside of the presence of the attorneys. If there was not a problem, then he would allow the juror to continue deliberating with the others. He goes on to say, I think the one with medicine we need to send home, she needs to take her medicine. I understand that. The person with the anxiety, that's a concern for me too. I don't want someone who is not functioning. I've got 12 jurors for a reason. The defendant's rights are protected by having 12 functioning jurors. Keyword, functioning. And it's got to be unanimous. So I've got a problem having somebody who says, I can't do it anymore. That's my concern, but I want to hear from everybody before I make a decision. Now, can we just all agree that this sounds very reasonable? Someone needs their medicine, someone is not functioning properly because of their anxiety, and someone's refusing to abide by the jury charge. The government asked the court to relieve the juror who needed medicine, remove the juror who was not compliant or following the law, and inquire about this juror who was experiencing anxiety to find out if this person was still viable as a juror. The judge is still being very reasonable. He said, I need to look into this because I don't want to see somebody trying to bump them off the jury. I need to confirm that. I can't just let someone be bumped off based on what someone else says. So, and again, he says a third time, I've got to confirm it. I can't rely on someone else's account. Then he says, with the consent of the parties, we're going to set up a place where I take a court reporter, and without anyone present but the court reporter, I will create a record. And with my deputy and my court reporter, I will ask the juror if there's a problem. The government asked them to do the same with the juror who's reported being anxious. The court asks, do I have consent of the parties for me creating a record to question the juror? Defense says, yes, you do have the consent, Your Honor. Defense did not object to the court's proposed procedure or request to be present during the voir dire. The last thing the judge said before leaving the courtroom was, I'm going to take action. Fair enough. Everybody happy with that? This was anybody's chance to speak up if they objected or had a specification they wanted added to that. But there was no objection. There was no request for clarification. There was no expression of confusion from the defense. When the judge returned, it notified the parties that it had relieved the juror who needed medicine. The court had also relieved the juror that was experiencing anxiety. He explained, "I spoke with the juror expressing anxiety, and she asked to be relieved and said she wasn't able to go forward, and I removed her. I relieved her. I granted her request for an alternate. I just basically said to her, 'Tell me, can you do your duties?' And she said, 'I cannot do my duties.' She's got medication issues herself, anxiety issues. And I relieved her. And the decisions I've made resolved the other issue, so I didn't have to address it." So Russell's counsel responds, "We would object not to the juror that was replaced for medication. We agreed to that at the time. But this second juror that was replaced about the anxiety is the one who we would like to make an objection to." To which the judge explains, this juror was very emotionally fragile and could hardly speak. He explained that the juror was on anxiety medication and that she was not physically capable or emotionally capable of going forward. He says, "I didn't think I had any choice." We never got into what's going on in the jury room or anything like that. She was shaking when she was speaking to me. There wasn't any confusion about that one. Now come on, really? Does that sound like someone who should be forced back in there to decide someone's fate? And surely, had she been forced into it, there would be an appeal about that. This woman wasn't functioning. How could she decide someone's fate? So the judge made the decision that she was not fit to continue her duties and replaced her with an alternate. Now, once these alternates were put in, deliberations continued, and the jury reached a verdict within an hour. And defense again reiterated their objection to replacing the anxious juror. The judge says, "I did what you all asked me to do." But defense says, "I'm not asking you to do anything differently now. Our understanding is that's essentially with the case law, it's akin for moving to a mistrial. We object to replacement of one juror." To which the judge asks, "On what basis? Because I asked you what did you want me to do on these, and we agreed I would talk to the juror, who could hardly speak, she was so emotionally upset. And I asked her if she could serve, and she asked me to remove her, as she had written me already and asked me to remove her. So I was doing exactly what we all agreed I would do. And I'm a little bit perplexed to after the fact come in and start complaining about something on a procedure we had agreed to already. I tried to be as transparent as I could. I read everybody everything. I asked you what you wanted me to do. I interviewed the juror who was plainly incapable of continuing, and she was in an emotional meltdown, and I removed her. And that's what I understood we had agreed, that I would interview her and I would make a decision. And now, after the fact, you want to change that. You're a little moment late. I already sent her home following the procedure." Defense goes on saying that they thought that the judge would come back to tell us what the juror said or give us what your decision would be so that we could object to it. To which he says, "If I had come back and told you that she was emotionally incapable of functioning and she asked me again to remove her, you would have objected to that?" To which defense says, "I think we would have stated that it's a hung jury." Does he know what a hung jury is? The judge responds, "It's not a hung jury. I have alternates." You know, folks, to come in here after the fact, after the court laid it all out, and we agreed on a process, I thought it was very clear. But there's a record of her. I don't think anybody would really question. It's all on the record about what she told me. And I was, of course, following up on her request that she be removed and told me she could explain it to me, and she did. I don't want to invade her privacy, but she is on significant medication, and she was, in my estimation, in an emotional meltdown situation. And here's the thing. The judge's last words on his way out of the courtroom were, "I'm going to take action." Fair enough. Everybody happy with that? And no one said a word about being asked for their permission for him to take that action. The brief continues, "At no point did Laffitte object to the court having excused the jurors outside of his or his counsel's presence. The reconstituted jury," that's the jury with the two alternates, "convicted Laffitte on all counts." Now, immediately after trial, Russell's then lawyer, Bart Daniel, files a Rule 29 motion, which is a request for an acquittal. This is a normal process and should be done by defense, so it's not surprising that his lawyer did so orally immediately before the court at the trial and then filed a physical supplement to that on November 21st of 2022. This whole motion argues over claims against Arthur Badger, splitting hairs over how things were worded, but it's based entirely on the lie that Arthur knowingly and willingly signed over, both being personal representative for his wife's estate and also refusing any claim to her settlement. Now, Mr. Badger clearly told the court that he was never notified, let alone asked, if he wanted to give either of these things up. He explained that Alex had a stack of documents he put before him and would have him sign them all with no explanation of what they actually were. Mr. Badger, trusting him, signed all the many papers Alex put before him. This motion rightly goes nowhere, and the juror's verdict stands. Very similar to his good buddy Alex, Russell's team comes back 2 weeks later with, guess what? Affidavits from the 2 relieved jurors. It's déjà vu, right? When presented with these, the judge tells both sides to brief on their legal stance for whether or not the court should receive them. Before that's settled, they bring a 3rd juror affidavit, this time from the foreperson. Now, these affidavits are rightly sealed because they are from jurors. Jurors, we know, are protected, but we'll get a little glimpse into them in a minute. But first, Bart Daniel submits a motion for a new trial and judgment of acquittal, again mentioning their exception to words used in the Arthur Badger case, and evidence involving dissent and disagreement within Palmetto State Bank, which you'll hear more of those details in the upcoming limited series Cassidy Reads, where I'll be reading out this federal trial. As I mentioned in my last podcast, federal trials are not televised, but I bought the entire trial, and I will be recording each person's testimony individually and special things like opening statements, closing statements, and so on. So you'll hear all of these objections as they played out in the trial. They also go on to accuse the court of wrongfully refusing to admit evidence of Alex's illegal negotiation of checks with Bank of America. That will also be addressed later, and failing to instruct the jury on Russell's advice of counsel defense given. Some of these are points they're still arguing in the current appeal briefs. But let's get back to these juror affidavits. As I said, they are sealed, but Daniel here makes the claim that a mistrial was appropriate because whether the anxious juror, which turns out to be juror number 88, would have been allowed to continue or not. A mistrial? I mean, based on what law, sir? He mentions curative measures that he feels could have been taken, and he makes the claim that she was bullied off the jury. Now, when we went over this with Alex's case, we learned that even in the event of screaming, cussing, name-calling, angry outbursts, as unpleasant as it all may be, these are not reasons for a mistrial, and counsel knows this. But they say that juror number 88 was having anxiety because of the other jurors, and make the claim that she did not want to be removed. Thankfully, Judge Gergel had the court reporter present, and we have a piece of that transcript here. He asked, "Are you able to perform your duties as a juror?" And she said no. Judge Gergel, I received a note that you told me. Can you please call an alternate, as I'm experiencing anxiety and unable to clearly make my decision? I can provide more information as needed if necessary. So this is what was in her note. She specifically starts off by asking, can you please call an alternate? I'm experiencing anxiety and unable to clearly make my decision. Then he asks, you want to share anything with me? But don't tell me anything about the deliberations themselves, okay? So he's being very careful that nothing is done improperly here. Now we can see she's in distress. Even though we can't hear her voice, we see she says, give me a minute. So she obviously needs some time to compose herself here. Judge Gergel says, take your time. She goes on, I was very proud to do this. At one point, I thought I wouldn't be able to, but I'm prescribed medication, and I've been taking notes clearly. I have my decisions that I made, but I started to feel very anxious due to some of the reactions to my decision. Judge Gergel, avoiding that topic because it would have been wrong to delve into, he asks her the only important question. Do you feel like you can perform, or do you want me to replace you with an alternate? Juror number 88, Your Honor, I don't want to be replaced, but notice the but, and I'm usually very strong when someone's butting up, but I don't want to be trialed for my decision. He assures her, whatever decision you make is your call. She says, yes, sir. he gets back to the only important issue. The issue is, are you able to perform your duties as a juror? Juror number 88. At this point, no. Judge Gergel, okay, I'm going to honor your request to replace you then. So he asked her, are you able to perform your duties as a juror? And she said, no. None of the circumstances are relevant beyond that. It's cut and dry. The judge cannot enter the jury room, scold them like children till they all make nice, and hold hands through the rest of deliberations. How many mistrials would we have, or new trials, if that were the case? This is the situation with juries. It's unavoidable. But Judge Gergel was told by this juror that she could not perform her duties as a juror, and he relieved her. There were still alternates to take her place, which is exactly why there are alternates. What else would they be there for? They're exactly there for people who cannot continue with their duties. So after the replacement, deliberations continued. And the truth of the matter is that Russell's team would not have an objection to any of this if the verdict had come out in their favor. Now, in Exhibit 1 of the defendant's motion to seal, we see descriptions of these affidavits. Number 88, the anxious juror we just spoke about, and number 93, who was the juror that needed medicine. Now, these affidavits describe improper influences on jury deliberations. An improper influence is something outside of the jury. There is no such thing as an improper influence from other jurors. It has to be someone who is not a member of the jury or something brought into the deliberations that was not part of evidence. So citing improper influence is just simply incorrect here. It also cites their experiences as a juror and the circumstances surrounding their removal. Now, we've discussed the circumstances around their removal. Neither of them were incorrectly removed. And we discussed this in detail during Alex's bid for a new trial. None of these descriptions cited by these two jurors are legal standard for the right to a new trial or for a mistrial. On December 20th, 2023, Daniel files a motion for a hearing on the affidavits. Then on December 21st, Ms. Limehouse responds stating that the court may impanel up to 6 alternate jurors to replace any jurors who are unable to perform or who are disqualified from performing their duties. This juror was asked if she could continue, said she could not, and was rightfully replaced. The other juror had to go home to take medicine. Now, after this, there are several orders and motions, but they're all sealed because they are dealing with jurors. Now, on January 1st, Russell hires Mark Moore, who is currently still one of Russell's attorneys. He also hires Michael Parente. They file a sealed motion on January 3rd, apparently making the very same accusations, because Judge Gergel mentions it in his order, as we'll see. On March 6th, he gives his ruling in a 42-page order. First of all, pointing out that a motion for a new trial must be filed within 14 days of the verdict, and this motion was almost a month later. So that's the first reason for the denial. While he's answering their claims from this sealed motion, it becomes apparent that new counsel has accused previous counsel of not appropriately articulating their objections, saying that they had not advised Russell in his best interest about the jury voir dire. They also boldly proclaim that the judge should have given an Allen charge instead of replacing the anxious juror. You know, the juror who outright said that she could not fulfill her duties? In his long answer to this, Judge Gergel expressed that trial judges have broad discretion in this area of replacing jurors with alternates. He also cites many legal standards that judges may not have any conversation whatsoever with jurors about their deliberations, and that his only duty was to find out whether or not she was able to perform her duties. Bear in mind that at the point that Judge Gergel dealt with these jurors, no one had any way of knowing which direction the jury was leaning in their deliberations. There's no way that he was doing this to find favor in either side. He then goes on to add what we already know, and that's that an Allen charge is only given when the jury is at an impasse and they're urged to keep trying. And we reviewed this before. about what an Allen charge is. Before a court gives up and declares a jury a hung jury when they're at an impasse and can't seem to come up with a unanimous verdict, the judge will speak to them and give them this Allen charge, basically telling them to go back in there and try harder. It's not something you use because someone says they're having anxiety. This jury was not a hung jury at this point. He also addresses these checks that Alex wrote to Bank of America and his decision not to allow them into testimony. And it was because Russell was on trial, not for being fooled by bank deposits written to forge, which is what happened in Bank of America, but he's there for his fiduciary duties that he held with the clients that he exploited. And that happened exclusively at his bank, exclusively with him. And so he denies this claim. After addressing a few more minor issues, he denies this motion for a new trial. And during this time, Alex is in his own murder trial. After he testifies and states that Russell had nothing to do with his stealing, Russell's team files a second motion for a new trial based on so-called newly discovered evidence of Alex's testimony that was given on February the 23rd. Let's take a look.
I mean, there's some things in there that I do take issue with.
Okay. Which part of what I just asked you about the pliers do you take issue with? You take issue that y'all didn't conspire to do that, you and Russell?
Yes.
Take issue with that? You take issue with that? Okay.
I can tell you that Russell Laffitte never conspired with me to do anything. Whatever was done by me.
Okay. So you told.
Now the court rules that this did not meet the criteria for newly discovered evidence because his testimony had been requested for Russell's trial. But on advice from his law team, he said if called for a witness in Russell's trial, he would simply plead the fifth. And you cannot call a witness knowing that they will only plead the fifth for all the questions. So it wasn't exactly new evidence. Further, newly discovered evidence is limited by the fact that it must produce probable acquittal once put before the court. But this is not the case with this so-called evidence. As they say here, that this testimony is newly available, but not newly discovered. And secondly, and probably most importantly, the court finds that Alex is manifestly not a credible witness. Evidence offered during defendant's trial established without question that Murdaugh is a serial liar and fraudster who stole from his clients and law partners. He now stands convicted of the double homicide of his wife and son. It is difficult to imagine a less credible witness under these circumstances. So basically, no matter what Alex would say under oath in trial, it wouldn't be credible. So there's no point in trying to admit it, especially not trying to base a new trial on anything he said. And so this motion too is denied. After which the team then claims that the court erred by precluding him from calling Alex as a witness and then denying this new trial motion. But neither of these claims ever get developed again by the attorneys, and because they didn't in a timely manner, these objections are waived. So after all of these denials, a sentencing memorandum was written up on July 31st and filed on August 1st of 2023. This brings us an end to part 2 of Russell's federal appeal, but we'll pick up in episode 3 with the claim that the court abused its discretion by excluding irrelevant, confusing evidence that was not probative of bias or motive. And this has to do with some inner turmoil in Palmetto State Bank. Till then, this is Cassidy O'Connell saying stay well and stay tuned.